Joining me this morning from Wisconsin Institute for Law and Liberty, attorney Cara Tolliver. How are you?
Morning, Meg. I'm great. How are you doing?
Good. Well, we already admitted to each other that it's Monday, so we're as well as we could be expected for a Monday, right?
Exactly. Hanging in there.
However, there is, I think that there is some good news on the horizon with President-elect Trump, and a lot of what I hope, a lot of what we're seeing, these race discrimination cases that we're seeing all over the country, and even just the whole DEI. We're hoping that we can change it to DIE and facilitate the end of it. But in the meantime, I know that you have, you have some good news about a ruling that's protecting many of your clients throughout the country.
Yeah, so recently Will secured yet another significant ruling in its case against the federal government's unconstitutional Disadvantaged Business Enterprise Program, or DBE program, which is a massive federal affirmative action program in the transportation construction industry. The ruling clarifies and significantly expands the scope of the preliminary injunction Will obtained earlier this fall. So you might recall that in September, the federal court in this case ordered the United States Department of Transportation to stop using race and gender preferences that discriminate against Will's clients, Mid-American Milling Company and Bagshaw Trucking, when they go to bid on federally financed infrastructure projects like highway construction projects, for example. Will understood the court's initial ruling to apply to its clients in every state in which Will's clients do business. But the federal government refused to fully comply with the injunction and instead sought to arbitrarily limit the ruling just to the states of Indiana and Kentucky. So the new order here clarifies that the federal government was wrong once again, and the discriminatory preferences are unconstitutional wherever Will's clients bid on highway and surface transportation construction projects. And in practice, many other firms stand to gain from this ruling as well, since the order applies to all federally funded projects that our clients plan to bid. So other firms that choose to bid on the same projects as our clients will also have an equal opportunity to do so where they didn't before. All in all, the court's preliminary rulings against the government are significant because this DBE program is one of the longest standing and largest affirmative action programs in the country, and it has been using race and gender discrimination to keep certain people out for over 4 decades. So it's exciting that after 40 long years, various federally funded construction projects are finally being opened up for equal competition as the discriminatory barriers come down.
Gosh, and when we were talking off air, I said, I'm almost not, I mean, it's outrageous, but we've become desensitized to how these programs continue to discriminate against Americans. And it's almost as if, I don't want to say, it's almost as if we've come to accept that, oh, that's just the way it is. But I'm grateful for your organization for being persistent and pushing back. These attorneys that advise our federal government, our entities, our federal government agencies, I mean, do they get mail order law degrees, or is it that they're willfully, breaking the law, and it's they're just trying to push it as far as they can? I mean, what's your opinion on that?
Well, I do think in this particular case, the DBE program, as I mentioned, it's been around for some 44 years. So a really long time. And there are 4 circuit courts of appeal that have previously upheld this thing to be constitutional. We think that those opinions are wrong, that they don't comport with equal protection jurisprudence, that this program has been unconstitutional for a long time, if not since its inception. But in any event, the Supreme Court made a very strong ruling a couple years back, really clarifying the law as far as equality goes. And it's clear that this program cannot survive the standards set forth in that opinion, which really just reinforced existing precedent. So, we're really excited because our clients, both of them in this case, they go where the work is, and at least one of them routinely does business throughout the country and across dozens of states. So this injunction has the potential to have nationwide reach, and that nationwide reach unlocks the door to these federally financed projects, again, not just for our clients, but also to other firms. Since, as I mentioned, the order applies to those projects that our clients want to bid on, and other firms could be likewise bidding those projects. So in terms of next step, I mean, things are looking very favorable for this case. Certainly, the court's issuance of a preliminary injunction for us, followed by yet another ruling significantly expanding that injunction, means that we're also likely to succeed at the final judgment stages of this case. But there are also potentially some very exciting changes on the horizon. A new presidential administration is imminent, and I would like to think that it would be unlikely for a second Trump administration to opt into the continued waste of taxpayer dollars defending the DBE program's clearly unconstitutional race and gender preferences. So, that said, I always say the DBE program is 44 years old. It has seen 6 different U.S. presidents, Democrat and Republican alike, including 4 presidents who served 2 terms. So I certainly hope that Trump's Golden Age agenda will prioritize the elimination of racial discrimination in America. But, as you mentioned, it's kind of this thing where it's like we've become desensitized, and, it's something that, we have to continue to stand up and work against when we see that going on. So that's something that we're going to continue to do.
So, I mean, being the devil's advocate, who will suffer as a result of the elimination of this DBE program? I mean, anyone? I mean, because isn't it supposed to be about helping those that are most qualified, or that have a great possibility of being successful, and it shouldn't, regardless of how they look on the outside?
Well, it should be about merit. The company that can do the work for the lowest cost is the company that should be given the job, right? That's how it should be going. We shouldn't be looking to somebody's skin color to make that determination. But that is what this program does. And since it is busy prioritizing race and gender, things like quality and cost go, they're deprioritized, right? So taxpayers have been funding construction projects at higher costs for decades. And the program may in the same way work against quality because it's not prioritizing the right things. So, I mean, in terms of who suffers, I mean, I think because for so long, certain firms based on race and gender have been getting these preferences. Of course, those firms are going to look at this as a loss. They think they're entitled to this. They've been given these preferences for 4 long decades, and now it's like, where are you taking my program? So, I mean, we can kind of see that sector of the industry probably concerned about, the loss of these opportunities. But this is something that they should have never necessarily been given in the first place, just solely on the basis of race and gender. So this is a win for everybody, because when you discriminate on the basis of race, not only are you discriminating against a person by not affording to them an opportunity to do a given thing, in this case, federally financed road construction projects, but you're also discriminating against the person that you're giving the opportunity to. You're saying, in this case, that person is disadvantaged solely on the basis of their skin color. That's a demeaning conception. You don't know anything about that person. You don't know anything about their circumstances. You look at their skin color and you feel sorry for them, and you give them this opportunity. So in terms of who wins, I think everybody wins with this. The taxpayers win because they're funding projects at lower costs. and people are getting the opportunities that they should get based on um, their ability to do the project and the cost at which they can do the project. And that's how it should be.
Cara, wow. I mean, I wouldn't have said it better myself. And I think that's the part that's always surprised me, is that those who are given a special program, that the message that they're being told, and this is the left's MO, is that the message they're being told is that they could not achieve it on their own. They could not ever strive to to accomplish anything without the help of the I don't know what you want to call him, the angry white liberal that is offering
Mhm.
this to them. And I mean, it really is insulting, I think, and I think, as you said, demeaning.
Yeah, definitely. I mean, and it's like totally backwards, right? I mean, these opportunities are coming from um, these politicians and these elites that are like, well, we're going to look upon you as disadvantaged and give you the. I mean, they are the discriminators in this case, and they continue to be the discriminators in this case. And folks that are buying into that aren't helping anything. They're making it worse, and they're um, just reaffirming and confirming discrimination every time they engage in those preferences and supporting those preferences.
I love that you reminded me too about Trump calling his agenda the golden age of America, or the golden age agenda. It's just it gives me such great hope, and I don't know, it's there's like this new renewed promise for the future of our country, and so grateful
Mhm.
for
Yeah.
that, and grateful for your organization too. Thank you so much, Cara, for joining me. I appreciate it. For our listeners, you can go out to will-law.org for more information about it. Have a great day. Have a great week.
Thanks so much, Meg.
Thanks, Cara. Going to a break. We'll be right back on the WSAU Wisconsin Morning News.